here, we've probably had, I can count on 2 hands.
We're live, by the way. Just
Oh, okay.
so.
That actually attend, just that want to come as part of the open meeting thing. It's just not, people are just not there. It becomes tedious and boring to the regular Joe. So we are.
Are you ready?
We're 29 right now, so just remember how it starts.
Okay, it is Monday, May 9th at 8:30 a.m. This session of the Aransas County Appraisal Review Board. You have a quorum?
Yes, we're good.
We have a pretty full agenda this morning, although we have to start off with one hearing. Is that person here?
They are not.
Okay. So we have 15 minutes to allow them to come. Let's go ahead and just move forward on the agenda a little. I don't see any citizens here or general citizens to make comments.
Scott, is there any in Zoom that
There are none.
there are none that are indicated in Zoom?
Okay, so let's move down to item 9, which is the previous meeting minutes. Should have those tablet. Those were distributed last week to you folks. Does anybody have any additions or corrections that are required to the April 11th meeting minutes?
Yeah, that's.
20 seconds.
Unless just nobody.
All in favor? Anybody opposed? Okay, so the meeting minutes from April 11th stand approved.
And she always would put 2 articles, is that what you put at a time?
Yes.
Yeah.
These other items are probably a little longer than 15 minutes. So,
We could report, we could do this, the supplements if you wanted.
sure. Okay,
Okay.
let's do that. So we're down. Yeah, starting at well, chief appraiser motions for corrections of the appraisal role.
It's under supplements.
Right, item 15.
Yes.
Yes, we don't have any chief appraiser motions or joint motions. There are several items on the agenda that we don't have any business.
Okay. So the only thing we've got then is item 15.
Correct.
Okay.
The best way to look at that is you could look at the certified changes, summary of certified changes. You can look at those individual, look at those individual group numbers, the 401, 402, 403, 404, 405. And you can see how those specific groups were changed. just to summarize, 401, you have ARB corrections for 25D motions. Does everybody see a page like this? Looks like this. Certified role changes summaries, which is
Right, so, okay.
looks like this.
And one more tap.
So, group number 401, from top to bottom, ARB corrections for 2520 motions. You see that anytime you have parentheses, that's a declination of value coming down. Second one is arbitration award. As you know, there's this ARB that makes decisions past year level. There's what's called arbitrations and lawsuits. And so that was an arbitration. Moving down to group 402, you have the de-annexation cap by board resolution. Again, that was, as you know, that was an action item last meeting in which was from a previous lawsuit that the city of Aransas passed. The citizens prevailed for the annexation or the illegal annexation as they refer to it. And so we did a supplement change here. So that's the 402.
What are the three columns?
What are the three columns of
So the first, the closest column to the
the
left is what each year, how much the value changed in each year. And then the second column is the total of that. And then the next two columns are just the same.
Okay.
Yeah, they're the same thing.
So it's so if you take the 194 plus the 20, come up with the 215. It's for an example, group 401. Moving down to group 403, you have property owners motion that resulted there on that first line item, and then another arbitration award, the second line item. Moving down to group 404, you have legal appeals and agreed judgments. Again, there's lawsuits that are being either settled or agreed upon all the time. So these are from previous years. You can see one year was 2019, the other year was 2020. And then the last one is just exemptions that were applied. Certified group changes at 405. It's just, those are just corrections. Disaster exemption removal, correction split, there's no value change there. And if you want to look at the detail of each of those groups, you go back one and you go to the supplement detail role and look at the individual groups and what they look like. 401, 402. 402 is kind of big there. You could look through all those particular things if you wanted to. Again, the summary is a good way to look at just, what was it generally. It was either an arbitration, it was a lawsuit agreement, and then you can see the value there.
In the detail, why are majority of these show $0?
Yeah, those are probably just exemptions. If there's assessed value difference, they're probably just exemptions that are either removed or added.
Right, an exemption changes the taxable value, but it doesn't change the assessed value.
Most of these are zeros because they're exemptions.
Okay.
Like if you look at group 402, and then, yeah, there's just, they're not. Except
Group
402,
402 is the big
Yeah, the big-
de-annexation.
the big de-annexation.
So the city of Aransas lost 51 million in assessed value. They no longer have those properties.
Yes.
It didn't affect the county or any other entities.
Because they still are in it.
Right, but it affected the city of Aransas Pass.
Gotcha.
Yeah, it assessed value, taxable value, different. I guess that biggest listed zero,
Come
Is
in
it
when
the-
you're ready.
if you think about it in this way, the market value for those properties didn't
Oh,
change.
okay.
The taxing unit got removed,
Show
and
'em.
so the taxable value changed for that entity, but the assessed values went to report that. So
So these are all the properties that were in that area?
that's correct,
You-
right? 25B, Robin.
You're welcome.
So I'm kind of confused. Are we talking about city of Aransas Pass right now?
Yeah,
So city of Aransas Pass would have had their taxable value changed because of exemptions that were allowed, and also the assessed value, because they no longer have those properties at all.
So they were taxing those people?
They annexed them and we
Okay.
added it to the roll. They were taxing them. Citizens brought a lawsuit. They said, no, it's not valid. And so they were de-annexed. And
Mhm.
so this is everything away from the city of Aransas Pass now.
It's now in our county, in Aransas County.
It's
always
still in
been-
Aransas
It's
County.
always
Well,
been,
it's always been.
it's always been in Aransas County. The best way to think about it is that this whole thing represents Aransas County. This represents the Aransas
Okay,
County Independent School District. This represents the city of Aransas Pass. It's just blocks within the blocks. And what the city of Aransas Pass attempted to do was try to change the shape of the block, and somebody brought a lawsuit and they prevailed, the citizens prevailed. But what you see here is Burton and Danforth on all these.
Mhm.
This is basically the city of Aransas Pass. That's why the summary at the end of the detail shows the $51 million.
Mhm.
But it's a taxing unit thing. It's a little strange. And then if you move down to group 4.3, you can see that it's just a few properties. I think they're lawsuit changes. That's why the summary is so helpful.
Yeah.
It's easier to read.
In group 4.4, you'll look at KOTM and Rockport Cottage Company and Madison Asset Development. That's basically one individual that owns those companies, and a lawsuit was settled, but it was a lot of properties.
Looking on my tablet and it doesn't seem to be behaving right. I don't know if it is for y'all's.
Ours are doing okay.
That's fine.
Doing fine? Okay,
Yes.
So that's the, and then at the very top, you have the supplement order approving records. That's the one that you can sign if you approve it.
What do we need to approve now to certified wall changes?
The supplement law. Item number 15.
Here's the-
Make a motion that we accept the order approving supplemental appraisal records as presented by the district.
I'll second. All in favor?
Aye.
Anybody opposed? Motion carries. All right, what time we got? 42.
What is the other item you did, number 9?
Yeah, the minutes, number 9.
Number 10, we don't have those letters, right, Val?
correct.
So number 10 is, there's no action on number 10.
Okay, let's get ready for the discussion on the attorney. I wanted to dial in. I'll give you the number value.
Okay.
You might not want to say that.
Oh, yeah, you
not
might
wanna
wanna-
say it out loud.
I can just look at
Yeah.
it.
I mean, somebody requested, I guess, I mean, over record, but
Hi Judy, this is Scott Wager with the Aransas County ARB.
Good morning.
Good morning. If you would just hang loose for a minute, we're about ready to start your, the agenda item dealing with our representation, okay?
Okay.
Hey, I don't think there's. The hearing was a no-show.
so that's item one. What item was that one? Number two?
Number 2. Okay, we're gonna go on to item number 4, which is consideration and possible action on the selection engagement of a new attorney to represent the ARB. Let me just preface this discussion. Our attorney had been Skip Henkel, and there was no real issue with his services per se. Skip had talked to me a number of times about wanting to resign from representing us. His area of expertise is commercial litigation, general business, and real estate. And so it really does not involve tax law and representing ARBs and so on and so forth. And he was not terribly comfortable with his ability to, in a timely manner, address issues that come up from the ARB. He was kind enough to recommend a lawyer, and Judy Hargrove is the attorney that Skip had recommended. Now, just as a little bit of background, we've included on your tablets her resume and also a summary of services. I won't go into details on that. We have Judy on the phone, and I'll turn this over to her in a second. But Judy has worked with Jim Evans for a number of years. They were partners. Jim Evans is the attorney that represents the appraisal district. So the two of them are familiar with each other and they've worked in the past. Judy currently represents 6 other ARBs in around Texas. And as part of the due diligence that I went through to look at retaining her, I did reach out to all of those ARBs and talk to all of them just to get a sense of whether they were, how the relationship was with working with Judy. All of them, every one of them that I contacted had positive comments about their dealings with ARB, or with Judy rather. Okay, so at this moment, as I said, I have Judy on the telephone, and I'll let her introduce herself and give you a little summary of her background, and then allow you folks, if you have any questions for her, you're more than welcome to ask. Judy, the floor is yours.
All right. I guess I'm on now.
Yes, you're on.
So I was just say good morning to everyone, and I can't, not if they're in person, but I would like to introduce myself just a little bit. You have, as Scott said, you have my resume, you have the services that the summary of legal services that I provided. So I'm not going to go into all that detail, but I wanted to allow you to, if you have any questions for me, to ask them, and for me to just say hello and say that I appreciate the opportunity to represent you. assure you that I do have a lot of experience in this area. I understand, yes, hesitation a bit because, as I told Scott, it's gotten rather complicated because there have been many legislative changes to the ARB's responsibilities and statutory duties lately, especially lately. And it is kind of, you do have to keep up with it. You do have to not only keep up with the legislation, but you have to be familiar, well, it helps a lot to be familiar with not just one ARB, but several, and many appraisal districts throughout the state. And that's all I do. That's all I do is represent appraisal districts and ARBs at any point. I have represented taxing entities in my career too, but I don't, that's not my specialty. I began this career at Linebarger, Goggin, many years ago, and practiced there for, gosh, I think it was almost 20 years. And I was trained by Russell Graham, Dale Linebarger, and Larry Kalam. They were the partners at the beginning. That's no longer the case. At some point, the firm Linebarger got really big and didn't really want to deal with. Well, there were two issues there. Jim and I really wanted to go out on our own. We wanted to specialize in appraisal district litigation and representing appraisal district. And the firm was fine with that. They specialized in delinquent tax collections. And so Jim and I set up our own firm. And then I practiced with Jim for 12 or 15 years. And then we split up. And I just wanted to go on my own. I wanted to move. I was in Austin for all those years, of course. And then I moved to Sealy, Texas, to be near my daughter and my grandkids. And they have a little farm here. And it's quite different from Austin. But I was ready to get out of Austin, to tell you the truth. It wasn't necessarily the place I wanted to be anymore. Too big, too crowded, too much traffic, everything. So I moved to a little small town here, Sealy, Texas. And hopefully it will remain a small town for a while. It's outside of Houston, but so it's, the growth is coming here. But right now it's a small town, and I really enjoy it. And I just specialize right now in my clients, and have the ones that I've had my clients for many years. And so I have experienced pretty much everything they have to deal with, and I think that gives me a perspective, on helping you in a way that's very practically oriented. But fees are very reasonable. We try, us appraisal district lawyers, we try to keep our fees, well, they're low. And because we know that our clients can't afford the fees that private firms that represent private entities charge, but that works out for us. And so anyway, that's who I am. I have done this for 30 plus years now. And that's my specialty. And I guess really that's all that I wanted to say, unless you have any questions for me about specific types of information that you might request from me, or specific assistance that you might request from me, or anything else.
Anybody have any questions you want to address to it? No. Okay, I will mention that we hit the ground running. Judy actually did a little bit of work ahead of time before we got this, before I had the opportunity to present this to the board, because we had that one item relative to the letters, one of the letters that we had table discussion on. Yeah. So that worked out well in terms of her being available and certainly jumping in to help on that. So if
I try to be available. I think that I am. But I don't do that much except for work anymore, unfortunately. And so I do try to always respond. I mean, that's one thing that I do. because I know that how important it is. When my clients need something, they usually need it right away. I don't know that. So I pretty much always available, either by phone or email or what have you. And I have been actually looking a lot at the new statutes for this year, and there's a lot of ins and outs there. But one thing that I do for some of my clients is training every year, and I don't do like the training that the comptroller does. I do more of the, I do with some of my clients on a session after the legislative session is over or before they start the hearing process in the current year. And we just talk about some of the changes, the legislative changes, and refresh some of the newer members, refresh the older members that have been on the panel, and then also sort of explain to the newer members, I think, what is really, really important for them to know, which is their role and how they should go about doing it. So that's one thing that I'm certainly willing to do. But most of my ARB clients, because they handle things at the administrative level, I'm not often really needed by most of my clients, to tell you the truth. They rarely are involved in litigation. Sometimes they are. If they are, it's usually a mistake by the person suing them because they're not allowed to be sued in tax code appeals, as you all know. So if I do ever get involved in litigation, it's usually just to file a plea of jurisdiction and resolve that kind of issue. And so since they make administrative decisions, those are appealable by the protesting party de novo, which means that in district court, a taxpayer can appeal, and it doesn't matter really what the ARB did. It just, they have a right to start over, basically, fresh, clean slate. And so I also handle those appeals for appraisal districts. So the roles of appraisal review boards are very different from appraisal districts. Appraisal districts are the ones that get sued, and ARBs are the ones that make the decisions and don't get sued. But I'm just, so I'm available for those kinds of things whenever legal questions do come up. Certainly I am, and I have represented ARBs in the past where in large districts where they do have questions all the time, and then I'm getting a lot of phone calls all the time. But in most cases, it's just a few things that you need at the beginning of the session.
Judy,
Maybe, yes.
Judy, this is Mike Soto here, the chief appraiser for the district. That's very refreshing to hear. We've been, we as the district have been in positions where, the ARB members themselves are looking for some kind of guidance, and we have to tell them, we can't give you any advice. You need to seek your counsel for that. So it's refreshing to hear that you want to be engaged, at least on an annual basis, to kind of go over some new legislations, to reiterate the ARB's roles and their duties, their obligations, what they need to focus on, what they need to steer away from. That's refreshing to hear, and no degradation to Mr. Hinkle, but it's just like anything. Some people specialize in bone medicine and other people specialize in blood medicine. Doctors are different. Lawyers are much the same way. They specialize in certain things. So that's refreshing to hear.
Yes, exactly. It is. And obviously, when you specialize in something and that's all you do, you're very familiar with it. And I have, as a lawyer, I'm frequently asked legal questions by my family and friends. And so I know how it is it takes a lot more time to go and try to figure out something for someone when you aren't fresh with it and familiar. So yes, that's all I do. So I can guarantee that I will be familiar with pretty much any issue that you have. And I understand how things work. Sometimes the ARB, as you say, that's true. Sometimes the ARB does need legal advice during their hearing process or doing a specific hearing even because they want to get it right. They really do. They want to get it right. And when it's a legal issue, oftentimes it's complicated. And of course, you're going to hear different opinions. And the ARB cannot rely on the appraisal district's legal opinion. And they shouldn't just automatically rely on the taxpayers' legal opinion either. So they do need their own legal counsel.
Yeah, that's very refreshing to hear. There have been situations in the past where, I will present the district's position as summarized or, by our legal counsel, whom you know very well.
Yes.
And you may or may not agree, with the ARB's, position as it relates to that, because we do have different duties. And so that's just refreshing to hear. It's good.
Yeah. Yeah, it's good that it's this way. I represented a lot of ARBs before, and I also represented the appraisal district. And of course, that was many years ago. And that just really it really caused a lot of problems. And so now that they made it legal, that the ARB has to have its own counsel, and I think that's a good thing. I don't see any, obviously, whenever I'm dealing with any issue for any client, my approach is always, I really believe in communication. So I really want to talk to the other side attorney. I want to know what they think and why. And a lot of times we're able to resolve things that way. But sometimes we disagree. And so that's absolutely right. The ARB sometimes needs to have its own opinion from its own lawyer that it trusts. Obviously, you have to trust your legal counsel. And then you also, as the ARB, you have also in making any decision, you have to go with that there's evidence presented and there's different ways to interpret evidence presented. So a lot of your decision making is about trust and what you think is the most reliable evidence. Yeah. Well, anyway, I'm sorry, I'm maybe talking too much, but I do, there's a lot I could say. And obviously, if we ever do get to have a conversation or a meeting, we would be able to do that. But right now, I just wanted you to know that sort of my approach, my philosophy, and my responsiveness that I intend to provide you.
Okay, the involvement, again, is an interesting thing, because last year, I don't think we had a single need to reach out to our attorney. Maybe one.
Charlie did several times.
Last year?
Yeah, absolutely.
Okay.
The responsiveness associated with that was what you're referring to, I think. So,
I remember.
yeah, I do too.
So in any case, it seems that at the beginning of the protest season and dealing with the changes that come from updates to the tax code and stuff like that, it is very helpful to have an attorney available to rely on, and it worked out very well with Judy's availability and my need to get some things resolved. So.
Well, I'm available for, like I say, if it's a full board meeting, that's one thing, but sometimes you don't need that. You just may have the chair call your counsel and get some advice on something. And so that happens sometimes too. But yeah, that's whatever you need, and however you need, it to happen. And I totally understand all that. But if you have any questions, I can answer them now, or if any come up later, that's fine too.
Okay, if we don't have any other questions right now, I would entertain a motion to retain Judy as the ARB's lawyer.
I make a motion that Aransas County Appraisal Review District Board hire Judy Harborough as the attorney for the ARB.
All in favor?
Aye.
Anybody opposed? Okay, Judy, the motion is passed. Appreciate you being available this morning to introduce yourself and address any questions.
Absolutely, and I just have one question. You had discussed earlier, Scott, that you thought the ARB wanted a contract, and I didn't know the proposed contract to you. So if you want to modify that, or if you don't feel it's necessary, either way. I personally, as I told Scott, and I'll tell all the rest of you, I don't typically have contracts, because again, the reality of legal counsel is that you can fire them at any time, for any reason. So I don't really think the contract does much in this context or is necessary. But if you want to sign that contract, you can certainly do that. At least it does set forth this as far as my opinion. So.
Yeah, I have that paperwork. I would frame it as an agreement as opposed to a contract. And I will go ahead and sign that. I'll forward you a copy of the signed document and then pass that over to our tax liaison who handles our accounting and stuff like that. And then I'll also get back to you. About any specifics about invoicing and that type of thing.
Okay, very good. Very good. Thank you all very much. I appreciate it. Look forward to working.
Thank you.
Thanks, Judy.
Am I excused?
Yeah, unless you want to stick around.
Well, if you want me to, I will, but if you just want me to go now, because get off the clock, I can do that. But if you have any other issues, I'm sure give me a call.
Yeah, we'll do that. We'll just give you a call if something comes up. Thank you.
Good luck with everything. You're right.
Yeah, we were, I think, a little, what? To have her recommended to us with her background and experience. And the fact that I did reach out to these other ARBs just to make sure there wasn't anything that needs a little pick me up.
We'd like some coffee.
Anything I needed to be aware of, and again, all of the responses were very. Okay.
I'd like some. Do you have anything in?
I don't have anything in.
Oh, I'll drink it like that. That's okay.
Let's take a 5-minute break. I wasn't listening to that.
This brought us topic.
Oh. I'm sorry. Yeah, let's take a.
Are these fees pretty regular? I don't know what the previous attorney.
Yeah, I checked the previous attorney and it's slightly higher than, I think it's slightly higher, although from the invoices, it's kind of difficult to figure out what his current, hourly rate is and so on. Because they do get granular in terms of not charging you specifically, an hour's time for 5 minutes worth and that kind of thing.
I think it's great that she's specifically addresses ARBs as opposed to skip, and I know skip was more general.
Yeah.
I think this is a great choice.
And Skip's comments were, he can play any game per se, and a lot of the things that we brought to him required some research. That he said, somebody more tuned to ARBs and tax law may be able to just, knock this stuff out real quick. So yeah,
That sounds fun.
She sounds very qualified.
and I'll say all of my contacts and dealings with Skip have been positive as well. So I don't really have any issues from that standpoint.
5-minute break.
Yes, please.
And we can kind of show y'all around where everything is. You might have already been in, but yeah. This part of the building's the same.
Did you pay for that copy or?
I know. I wasn't sure if I liked them.
Oh, well, that's why I thought it,
Yeah,
yeah.
and when I put it on, because you really couldn't tell from the picture.
Yeah.
I-
From the picture?
Yeah, because it looked like it was tucked in.
Oh, no, I didn't know we were doing
Where'd you get it? If you don't mind me telling.
No, that little shop in Aransas Pass next to the thrift store.
Thrift store in Kansas.
Yeah, on the main street. Oh, there's a,
Really?
yes.
I have to
She
go there
always
then.
has- She always has, carries a lot of linen. And, that's one of the reasons.
Well, I'm gonna have to go there, and I ordered this online. And the pants too, online. That's funny.
You want to get their prices.
Oh, see, mine's 20,
Yeah.
23, I think,
She,
25.
that's why I was surprised, because she only has one of a kind.
How fun, on the main drag.
You know where the theater is?
Yes,
Okay,
Rio
she's
to
right,
Rio.
yeah, she's right next to that.
Okay,
Okay.
are we done? We were just,
Sorry.
that's okay. I'm gonna have to doctor my coffee though.
Yes, come on back.
So. Oh, wow.
Oh, okay. Right hand cabinet. Yeah. Wish I would have done this last week.
Well, I'm sorry that I was just kind of asleep at the switch, you know? And I don't know when you're gonna take time.
Well, again, it's one of those things too, you know, honestly, what happens here only happens once a year. And when Donna was Ricky, this wasn't happening, was not.
That's right.
Today, that's me, and then it was like something over at that point. That was really.
I can't believe this is the same space, isn't it?
Yeah.
It seems so much bigger. Okay, this is Barbara.
Yes, so. We have this door, the doors aren't in yet, obviously. Yeah. So a door will be here, where you can just go, to the back, you don't have to go out to the front area. And then this is going to be a door with a window, like next to it. Yeah. And when you do, we'll put the frosted kind of tint on.
Matter of fact, Matt, right here, I can email to you.
Yeah. We can be found, I'm sure. Well, I'm certainly glad we didn't have that protest. I had a couple of people call me though, Ron, about my taxes and I can't talk to you about that. Shut them off right away.
And we, even though we're on break, we're still live
Oh,
here.
okay. So I told them, "Well, it's a process you go through."
The only time I ever eat candy is when
We have a kind of a tall table on order. So we'll put over here and we'll just have like a coffee carafe.
Oh.
And then the candy will just set over here.
Oh,
I
good, good.
can help ourselves.
I think you have to get it.
Yeah.
Yeah.
I'll title this breakfast, so.
Yeah,
I didn't have.
Socially
Acceptable.
acceptable. Now, we could be giving us, like you did in past years, a week out meetings,
Sure, yes.
and we don't, when I called the gals the other day, they said probably the 23rd we would start. Is that the first day?
Yes, so Beth has scheduled the 23rd, 24th. So that week, we're gonna hit the ground running. We should have hearings through Thursday of that week and just on from there.
Sometimes they're just mornings, sometimes they're just afternoons, so each Thursday usually there is something to follow.
Yes. I'll be sure to do that.
That'd be great.
Okay. Ready to roll in?
Mhm.
All right, so we're gonna start with item 5. After our last meeting, when we decided to have at least a session among ourselves to talk through anything related to these procedures, and then follow that up with a public hearing, it was believed at the time that we needed to have a hearing. And since then, the lawyers and then also the PTAD, their website was updated, just saying, we just need a public meeting to make these procedures available for any discussion. And so at that point, I said, well, let's see if we can combine all these together and do them on the same day. The stuff I distributed to y'all last week, what I had attempted to do was just highlight in those areas of the procedures where there had been changes. Now, we had procedures before. Those were the ones that you got at the beginning, our first meeting. And luckily, they had been patterned pretty much after the comptroller's model hearing procedures.
Yeah, I kind of expected it to be.
So we didn't have to go reinvent a lot of wheels to integrate changes or updates from stuff that was done before. However, I did annotate those sections in green, which are areas where we had enhanced the model hearing procedures, which is allowed. First off, if you recall, the tax code was updated in 2021 to require that we follow the model hearing procedures. And they specifically said we could enhance them, add things, remove things, as long as it didn't run counter to what the model hearing procedures had specified. What you'll see in the green areas in the stuff I distributed to you guys are areas where we have enhanced. I would characterize it as enhancing the model hearing procedures. So it's stuff revolving around specifics around the 2525D calculations and the fact that we go through a regular hearing, come to some conclusion, and then apply the formula for 2525D to see whether or not it applies.
So number 4, that's where are we talking about that?
Well, I was just going through in general in the hearing procedures, because
Okay.
the stuff that's in green are things where we've added or enhanced the stuff in the model hearing procedures.
Oh, okay.
Yeah. In item 4 that Kathy was just mentioning, what you'll see the main difference there is in the actual steps that we take during a hearing.
we have enhanced those steps in the procedures to include specific times relating to various parts of the hearing where the protester goes first, he has 5 minutes, followed by 2 minutes to get questions from the district, followed by 5 minutes for the district, followed by 2, that back and forth. And we've added the specific times involved, which goes a little further enhancing the steps that they had in the model hearing procedures. And then in item 5, evidence considerations, we put specific information related to how we handle or how the district handles evidence that comes in various digital forms, either on USB keys or CDs or that type of thing. What types of formats are allowed, acceptable and not acceptable. The red items are items where I have either added or changed to some extent the information that's in the model. And a lot of it is fairly inconsequential. It's adding specific details that were just either missing or referenced in other sections and then just needed to be put into prior sections, particularly in the area of postponements and that type of thing. I'm going to skip for the moment 3.4, which talks about panel assignments, because that's going to be a significant thing that we're going to deal with.
Okay, 3.4, which is ARB panel assignments.
Yeah, 3.4. Yeah. Main topic 3.
Roman numeral 3,
Yeah.
subsection 4. You're gonna skip that for the moment.
Yeah, we'll cover that in just a second. But we'll start talking about it. Okay, I think that's it in terms of what I was going to mention for the updates. Does anybody have any questions about the procedures as they stand with our proposed updates? Okay, that being the case, the next thing I want to talk about is Roman numeral 3 subsection 4. In my first go around on going through the comparisons I did between the model hearing procedures, our hearing procedures, we previously had just specifically said 3.4 didn't apply. Because it's called ARB panel assignments, and panel assignments generally, for sure, special panels do not apply to our county because the tax code says for counties less than 1 million people, then it's you don't need to support the ability to do special panels. However, what skipped my scrutiny was a section that got slipped in, so to speak, on what's called single member panels. And let's see, I think Val put it.
Yes.
Okay, great. I just put a couple of charts together that might help at least start things off with single member panels.
The single member panel means only one person from the ARB.
Yeah, and so right.
So you sent me something on single member panels?
Yes.
Okay, I probably didn't see the email yet.
Well, it only came in 10 o'clock.
I will run.
She's awesome, but not that, I mean, not that awesome.
Not 10 o'clock at night.
No, 10 o'clock, I know.
Okay. I'll at least start talking about the information. From your training manual, and both in the continuing education and as well as the new member, ARB member training, there is a section which says an ARB will sit in single member panels to conduct a hearing if the property owner requests that format in writing on either the notice of protest or by written submission to the ARB not later than 10 days before the hearing date. There are no designations or qualifications needed for the ARB members to sit in single member panels. If you were to look at the information relating to special panels, there are qualifications required to serve on a special panel. Qualifications relative to your background and experience and that type of thing, which is one of the reasons why special panels tend to only be available. They are only available in the larger districts, larger counties, as well as having some criteria on the types of cases that can be heard by special panels, having some pretty high dollar amounts associated with them, $50 million in a lot of cases.
So if you go back one, if you're in your hearing procedures, if you do the arrow back, there should now be a ARB single member panels option.
Are single member panels new? We've never requested that.
Well-
Request for that, so somebody's a brand new.
Yeah, it is new from the standpoint. The answer is yes. It is new, and let me just go through this other detail because we'll go through the sections of the code that talk about it. There's also in the model hearing procedure, section 3.4 does have this additional paragraph which talks about tax code 4145B4 allows property owner to request a single member panel to conduct the protest hearing. The property owner must submit the request no later than the 10th day before law. If the ARB does not accept, okay, so now if you look at the protest form, both the paper form and the online form, there is now a checkbox where somebody can request a single member panel.
Do they choose that person?
We'll get into that. We'll talk about it. Okay. Yeah. Because the next thing in the model hearing procedure is, okay, fine. So now we have this ability and potential need to support single member panels. If the single member who does hear a specific protest comes back with a recommendation as a result of their hearing that case, that recommendation is presented back to the full ARB. And the full ARB, according to the code, has the option to accept the recommendation made by the single member panel, or can, in principle, as it's written here, they can then turn around and say, well, we don't agree and we're going to decide this as a full ARB, or the chairman can request a rehearing using another single member from the ARB, choosing somebody who did not hear the original protest.
I have a question. Why would somebody request a single member?
No questions allowed. these are all good questions, and we'll need to,
But you're getting ahead of myself here.
well, not necessarily, okay? It's just that at this point, I'm laying out what this is kind of sort of about and giving you the sense that there's not a lot of guidance on this. And even looking at the tax code 4145, section B4,
Yeah.
says an appraisal review board shall sit in a single member panel to conduct protest hearings under this section if the property owner requests that the hearing be conducted by a single member panel, either in the written notice or writing submitted prior to, or submitted to the board not later than 10 days before the hearing. The next section is a short paragraph which says, if the recommendation of a single member panel that conducts a hearing under section B4 is not accepted by the appraisal review board, the board may refer the matter for rehearing to a single member panel composed of a member who did not hear the original protest, or the board may determine the protest. That's it, okay? It leaves a lot of questions.
It does.
As well as that's good and bad, okay? We can come to some conclusion, and then, again, working with our attorney can determine whether or not we're doing something that is running counter to the law or code.
We'd have to accept this.
We have to be able to.
4145.
Yes, because another section, I didn't refer to it, indicates that where special panels are only available in counties with population greater than 1 million, single member panels have to be available in all counties.
If I can give just a little bit of background for a couple of different things. Single member panels have been available to bigger districts for the aforementioned things. Either the level of expertise of a particular panel member was much greater than that, whether it was commercial or industrial, and the panel or the ARB as a whole relied on that individual for their expertise. The other thing was that, in bigger districts, you have more protests. They were able to eat the elephant, one bite at a time, much faster if they divvied up and then just, reconvene. And then have been requested. We're not talking about a large thing. We're talking about a procedure of
Requests, the chair appoints.
the individual requests a single member
the single,
panel,
okay.
but they cannot say, I want that person.
Okay,
That's the way I understand it.
Why would somebody feel that was an advantage?
There may be some perception by the person requesting single member panel that they do have a choice of, I want Peggy. Because there is nothing in the code that says they can't do that. Okay.
They don't know that they can't do that.
Yeah.
Right. I'm sorry.
But it may also look to them like if I only have to deal with one person, I can manipulate a lot better than I can with
Yeah,
a group of five.
you know, we will have to come up as part of our procedures, determine how we administer these single member panels. Because there may be a perception, I think a lot of people that bring protests to the ARB show up in person and would like a resolution then and there. That probably won't be the case, because the single member will hear the protest, hear the appropriate evidence on both sides, and then have to take a recommendation back to the full ARB, which may or may not, we haven't decided, we haven't come to a conclusion on exactly how we're going to handle these recommendations and voting on them and accepting or not recommendations, whether that occurs the same day, the next day, how we do that. There's also one more thing. And we just don't know yet. What we find in a lot of cases on protest forms is somebody checks every box. We have situations where you wish they had checked a few more boxes, but there are a fair number of cases where they just check all the boxes. And so I don't have any sense of whether somebody checked the single member panel request box because they just checked all the boxes, or whether there is a perception about what they need.
It's a yes, no thing.
Yeah, it's a yes, no thing. And I want to look at the protest form and see where it is in the form,
Yeah.
because that may be in a different section. I think it may be in a different section.
I think it is.
Yeah, which, yeah.
As well as the online form allows that selection too.
Yeah, but the point, that's, the point is that it's in a different section. And to your point, Chairman, to your point, there is a section where you have, like right in the middle where they can check all the boxes. But then when you get down to the other section, it says, do you want hearing in person, regular property owner? It's section 5. So it's a different section, and they actually have to check yes here. You want a single member. Do you request a hearing with a single member panel? Yes or no? And if they don't check either, then it's just a regular ARB proceeding. But if they check yes, then that's the ones that we're tracking right now are less than 2%.
I have a question about that. If a lot of people aren't going to realize what they check. What that means.
Sure.
It would be possible, or it could be illegal, as those forms come in for the office to contact us. Did you really mean you wanted one person panel? Normally, it's the whole panel. Maybe we could eliminate some of that. I don't know. It's just a question. I don't know if they want.
Yeah, I don't know that we can. Well, first and foremost, there's another thing where they can request an informal. So some of these, there's informals happening all the time right now. So some of these are just going to drop off. But if you're looking at, for every 1,000, that you're less than 20, you're like 14 single panel for every 1,000 protests. Even last year when we had as many as we did, you're talking less than a day and a half of single member panel. So it's not as big an issue other than procedurally, you just need to know what you're doing. And I kind of, not that I have a vote on this thing, but I agree with the sentiment and the thought process that it's probably going to be single member panels that are going to take just as long as if everybody were sitting here, because the person, I'm still going to be here. It's just going to go through the same procedure. And then they're going to have to take that decision back to the whole ARB. So that person's not going to probably get resolution on the day that they leave, or what they're probably not going to know.
That's why I wondered.
Yeah. So your point is well taken.
Let
Is that
them know that, guess what, we can do that if that's what you want. But here's the reality that depending on what the decision is, it's still going to have to go
then,
Do you really want to do that?
then this is what I would say to the district. I would say that if you want to do that as an ARB, it should come from you, because the protest, and have Judy maybe formulate a letter to all of these people, and then you have a good understanding that they really do want that.
And there may be a need for some waiver or something like that to follow up if somebody says, oh, I didn't know that. And then they have to.
Here's a question to do.
Yeah,
Yeah.
right. And she and I chatted about this stuff on Friday to some extent. And yeah, I've reached out to one or two of the ARB chairs that I talked to about Judy. So far, the people I've talked to said, what are you talking about? Because I think I think this is new news to a lot of people. I interrupted you. You were going to ask a question.
I think it was a procedural thing. Okay, so you have, just so I've got it in my mind, you have the single member presentation. And then they don't even know what you have decided at that point, because everything goes back to the board, right?
That's my question.
We
Do
don't know
you
that.
make the
The decision and tell them, this is the way I feel, but it has to go back to the board for approval, or do you
I
just say,
suspect that
thank you
would
for
be
the
the right thing to do.
presentation, we will.
to make the decision and then take it back to the board? This
Yes.
is the decision I came up with, and then the board reviews it and either.
We
agrees
obviously
or
need to come to
disagrees.
that understanding, yes or no. I personally think that would be the case where the single member and executes the same bloody process that we have for any other hearing, okay?
Instead of making a motion that, again, I'm interjecting, you should absolutely ask Judy.
No, you're right.
But if the single member panel, instead of saying where the chair would say, somebody needs to make a motion, the person would just say, I rule on equity, I deny the protest on equity, I deny the protest on market value, I approve the protest on this or whatever. You just make a motion, you just make a ruling rather than a motion.
But then the person,
And I'm just making an example of,
I know, but I think the person then would be, okay, that's the resolution, but excuse me, but I still have to take the whole board, and that could be changed.
Yes.
yeah, you're gonna have to explain that. It's gonna be more.
And I'm wondering if they're gonna hear that.
One person.
It still has to go back and be approved. by the board.
Is it more cumbersome? Yes. Is
Yes.
it part of the law? Yes. Are we gonna have to do it?
But asking them to make sure that that's really what they want.
Then that should be a conversation between you and Judy.
Right.
I mean, I think that was.
And just the process, and you can envision, just the process of taking the recommendation back to the board is gonna be really cumbersome. Because I, as a board member, it's not that I don't trust Ron, or I don't trust Peggy or Joanna.
You wanna know all the facts that.
That's right. I mean, it's like, what am I accepting, okay? Which means, if that's the case, I probably need to hear all the same thing that the single member heard,
So it's
okay?
double the work.
It would kind of seem that way.
It
okay.
seems that way.
Because you know how many times, not often, but you sort of have differences in opinion.
And what would be lost in that translation,
Yes, yes.
Yep. So,
Scott,
yes, ma'am.
is it a possibility that y'all could actually sit in the room?
That was gonna be what I was gonna throw out.
Oh,
And this is not, I broached this to Judy. She didn't have a conclusion one way or the other, but as a possibility in my mind, trying to come through procedurally, I said, is there anything that would preclude the full board sitting in during the single member session? Because we have to decide in a single member panel, are we going to do these, how are we going to do these as separate sessions or intermixed with regulars, where when it comes time to do a single member panel session, the rest of the board excuses themselves or not. So as Beth was suggesting, and I thought it might be an interesting thing to pursue, is have have the full board present but silent.
I don't think that's the intent of the law.
There's,
I think it's absolutely, it's an open meeting. Nothing can preclude you from being here.
yes,
Secondarily, there's nothing that precludes you from sitting in the next room and
Yes.
watching it live
yes.
and coming to your own conclusion. But I mean, it's all on how you want to do that procedure. I don't even know how, because it's so new to us, I don't even know how other districts do it.
Right.
But having said that, I will tell you statutorily, this is an open meeting, meaning all of you can sit in here and I can get my neighbors on either side and I can bring them in here and everybody can listen and everybody can go, well, that person got it wrong. Or, oh man, I agree with that person, that single member panel person. A citizen could have their own opinion and be silent. At the end of the day, once that single member panel renders a judgment, immediately after that, or later the next day, or however you want to do your procedure, they're just going to say, yeah, I remember listening to that case and I agreed with my member panel, or I disagreed with the single member panel. And they've already kind of done the science behind it.
Right.
But I think if I was the protester requesting single member panel, whatever, and I walk into the room and everybody's sitting there, not realizing it's an open meeting, still board members, it's still ARB members, and this all, why did I request a single one here? You guys are all sitting there.
They have to be explained, the legal
Somewhere it's gonna have to be
statute.
explained, yeah, because I would,
And that's-
I would be pissed, I requested one person,
Well,
now I've got a whole panel.
And, yeah, and we don't know. We just don't know what people are thinking as they're requesting this single member panel thing, and what the motivations are, and what they believe they're going to get or not get out of requesting that.
Some of them, they think that they have a better chance of convincing one person to buy.
I can't disagree that that's maybe the case in some of the cases. I just, because of the lack of specificity with this thing, it's a lot of conjecture right now in terms of, well, this may be what it is and maybe not, okay?
Wow.
Yeah, I know.
Can't we just take the whole thing?
From a district perspective, my suggestion would be, or it is my suggestion, that we would put all these single member panels to try to group them in like July 18th, and then there's another set
So
on,
the same person here, every one of them?
no, it's not that. It's just that you're gonna do single member panels on a specific day.
Yeah.
So that procedure doesn't get jumbled up into your regular flow and mess you up. Because you're used to doing it a certain way. 98% of them are gonna be this way. There's gonna be 2 of them that are gonna be this way. Let's get these 2 kind of a special day that everybody's on board with, like, okay, now it's,
Single thing.
now it's your turn and now you go in there and now you go, I don't know. I mean, that's your decision to make, but as far as from our scheduling, I think makes the most sense for the district.
I agree, but you still have to make a decision on it, that person's gonna come in, one person's gonna be sitting here, all 5 of us gonna be sitting.
Right.
Well, further question is, can't we take this discussion, attribute it to here, to Judy, and say, what might our option be? For the ease of doing it in an easier manner without getting ourselves all big
Right,
to do that.
and to be honest, yeah, go ahead.
I'm sorry, it also concerns me just a little differently, that we're going to say, well, I feel this way, and that person is gonna hear that as God's law. And then we go back to the full group, full panel, and they say, no, blah, 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 blah. And it doesn't go, but God spoke, and
Yeah, like the individuals can say, I requested a single person made the decision, why are you all involved?
Right.
Well, I think that explanation, it has to be explained, even as a single panel. We're all sitting in the room, we need to say, okay, this is a single panel, but the board is here because this is an open meeting, they are, allowed to attend. So explain that, the Open Meeting Act, and that way they're not confused, why is everybody sitting here, and I asked for only one,
That's why I think it'd be good if we.
And the taxpayer needs to understand, if he requested one, but the whole board has to approve. You need to understand that.
Yeah, because,
Coming in.
we're gonna make a recommendation, but it has to go to the ARB.
Right. And so in the perfect scenario, even if we were in a different room, or to what extent the single member presents a recommendation and so on, if the full board says, yeah, that's cool, that's fine, we agree, that's great. The real part of the challenges here are what happens if we don't, okay? And the code says, if we don't, if the full board does not accept the recommendation, that the full board can
Rehearing.
refer for a rehearing with a different single member chosen, or the board may determine the protest.
But it says to a single panel composed of a member who did not hear the original.
That's correct. Or
The board may determine.
yeah, or the board may just say, well, and we're
Right.
gonna decide.
It's just cumbersome.
Yeah, it
I
is.
think it's important that when they come in, as I said earlier, individuals requesting that there's some letter draft of it. You would-
Explains all this stuff.
So they come in here and they understand going in what could possibly
Right.
happen as opposed to.
Beth,
I said, once we figure out the way that it's gonna be handled,
Right.
we can always send out something to those
So they
people that
understand
requested it.
exactly what it is.
So they know beforehand what they're getting into.
What they're getting.
Yeah, and one of the things that I was saying that we should probably do this all in one day, but one of the things I wasn't thinking about is when you have an online protest, we've done online scheduling, so a person you might have these intermixed throughout a single day. It's just gonna be a thing. I didn't think about that, but online protesting allows online scheduling. That's something new for us this year as well.
But we wouldn't have to make, I see what you're saying. That's right.
It could just get intermixed.
So this is law.
well, the tax code is what I.
The tax code is what it says.
Yes.
So in all honesty, we have to approve it,
We have to do something.
do something. And then once we do it, then they can know how to proceed. The board can know, the district can know how to proceed with telling Jane Smith, do you really want this? If you want this, this is the procedure.
Yeah, there's a
Can
whole,
that actually be sent to?
sure.
You should ask that of Judy.
Exactly. Because
So
so have to
the-
make it very clear to anybody coming in that they're not getting fooled, where's my one person, so they'll totally understand what they, and maybe they'll say, well, wait a minute, I didn't mean that. As you said, people check boxes all the time.
I think it's, well, and this is just my opinion, I'd rather have the entire board hear this and have the different opinions rather than one, because that one person may get it wrong.
Yeah, but when
It'll
you
be
think,
their opinion,
and again, the preface for this is it used to be in bigger districts where you might have had a person that was really good in commercial and had a good understanding of commercial and income, the income approach, and they knew about cap rates and localized cap rates. And then you had another person that was an industrial specialist. And the rest of the members were like, they just trusted that person. And I think that that's where it was born out of. I don't know for sure, but I think that's where it was born out of. Where our cases are less so. We just have residential properties and land, and everybody has a general understanding. I mean, there are commercial properties, but again, it's neither here nor there. It is the law. You are gonna have to do it. You just need to decide how you're gonna do it.
Right.
I think can we panel this or hold on to it for our next meeting, to have a chance to noodle this or speak with you
Yeah, okay, so
without making a decision today?
we have some challenges, I think, on how we sort all this out and deal with it, okay? Recognizing that we have open meeting Act considerations, okay? So it's not like we can all get together at Panjo's and, you know, have some beer and chat about this stuff. We can't do that, okay? And
One of the challenges, Chairman, one of the challenges that you have is you do have the public hearing procedures proposed for an adoption by the ARB. And so that is on the agenda today, which is inclusive of the single member panel. And so, you know, one of the things that Judy had indicated is if you need me, you know, so you're left with this conundrum of you have to adopt this ARB procedure, of which one of the sections is the single member panels.
so I
That one out and just-
You can't,
well, here's,
or
Well,
I don't
To
think. you
adopt
can.
it, we just don't know how to adopt
here's what I think we can do or should do, okay? For our existing procedures that we're attempting to adopt, that we add in, and I did add in that section in 3.4, the paragraph from the model hearing procedures. That's it. And by the spirit of the law about meeting the model hearing procedures, we have done that. There are no other places in the model hearing procedures that address single member panels, nothing in their procedural steps or any other mentions. So at least today, I believe we can, we add that section in, and we can potentially vote to adopt the hearing procedures in that form.
You're talking about the blue, the stuff that's in blue? Can you get it there, answer it? Just so everybody's, and so I have an understanding of what I mean, if you can adopt it whether I think so or not.
That's right.
I just want to understand it. I just want to understand.
It's the blue, right?
Yeah, single member
Okay.
panels, V1, and it is, oops.
The markup is what you
The bottom one.
Oh, it's-
Yeah, the blue was,
the blue is what you want to add?
yes.
Okay,
Yes.
that's all. I just wanted to understand it.
And I actually, I mean, the section, the way it used to say is single member panels do not apply. And I actually had an error. I had the tax code reference 6.41. I had an error there. So anyway, yes, to answer your question, adding in that blue paragraph, which is the paragraph from the model hearing procedures, I believe.
And which heading are you going to have? Are you going to have the heading that says single member panels tax code 4145 B4? That should be blue.
6.425A.
No, okay. So we're under 4. It says ARB assignments.
Yeah.
You're actually striking special
No,
panels.
I'm not striking that, because and in fact,
It says do not apply, so it's.
yeah, I think, apologize if,
Oh, special panels do not apply.
Yeah.
So that would be in blue too, because you're adding that.
it was there.
Okay, got you.
And
Okay.
the only reason it was, I put it in red is because I changed it slightly. Because what I changed from our prior one is it just said does not apply. And so I added, I said special panels do not apply, and I added the tax code references as to why it didn't apply. And then the single member panel, I added that line below that in 3.4 and the blue paragraph.
Okay, I have a question.
Yes, ma'am.
Under the blue section, tax code
Yes.
section, all right, it says if the ARB does not accept the recommendation of the single family member,
Yes.
the ARB can determine the protest or refer it for rehearing to a single member panel composed of someone who did not hear the original protest.
Yes.
So
And that's pretty much exactly what the tax code says. It's in a slightly different order than what the tax code
Okay.
says, but it's the
That's
same.
That's what it
same
is.
thing.
It's the same thing.
What is it like if it's in green?
The green stuff is stuff that I added. It was missing
Oh, okay.
and I added.
But you added the blue as well.
I added the blue
Yeah.
just to make it, because, and maybe I confused things a little because I sent out stuff to you guys to look at, and it really just had red and green. It didn't include any blue stuff, and so as I was having to make changes to support the single member panel thing, I wanted to be able to highlight it specifically.
So just so we're clear, because my staff is gonna help you bring this together, can you articulate in verbal form what you want to happen after your adoption of the resolution? Just tell them what you want, like, to print.
Right, I will provide, and I have provided a PDF without any highlight.
You got that now?
Yeah, it's in the tablet even.
Okay, okay.
And
Under proposed?
Yes. And the green was actually, it's not part of the model hearing procedures, but it was in our procedures before, and
Thank
it's just like an
Things that we've
enhancement, an
enhanced.
additional.
I apologize, I messed that up, yes. So we had gone in and added stuff to the model.
So,
In past years.
so if you could tell me, where am I looking for, is it resolution? Not the resolution,
It is the
what's the name of the title?
Aransas hearing procedures for ARB V5.
Okay, so that's the one that has proposed on it,
Yes,
and that's actually what you're proposing.
yes,
We'll just remove the watermark
right.
Got it.
and it'll be, and put adopted at the bottom
Okay,
instead of,
And you'll see it does include the
The
section
stuff.
4.3, 3.4 rather, on the single.
Yeah.
yeah. Okay, that's a
Yes.
good one.
A question about this last part where it says that, let's see, ARB will determine the protest or refer it.
Yeah.
So at that point, it becomes us who decide if we're going to decide the protest or if we are going to refer it to another.
Right, we have three options as a recommendation coming back to the board.
Okay,
The recommendation being from the single member who heard that. One option is we accept it.
yes.
We accept the recommendation. The second option is if we don't, as a board, decide to accept it, we then have to decide, okay, what do we do next? And we have two options. One is we can decide to submit it to be reheard by some other person, single member person, in which case it comes back through the same process again as a result of that recommendation. Or the board can say, can render a decision as the board, which says, thank you very much, single member, we're gonna vote as a board to, what to do.
What happens though if you stop the one person, then you have to do the second person, and they disagree?
No, we don't, wouldn't go that way. If we accept the recommendation,
Yeah, but if you don't, then it goes to another single person.
it can,
Can,
Okay.
it doesn't have to.
and it's up to the board to
Yes.
decide that.
Yeah,
Yeah,
My point was if we did that
yes,
and those two individuals disagreed.
that has no, it's just like the first hearing never happened. Okay, so the second person to hear it would bring in a recommendation back, and it has no bearing on what the previous,
Still have to go back to the board.
yes, right, so you can get in this loop. All right.
Yeah, that's my point.
Oh, it's just, it is really convoluted and.
but the thing is, it's no longer the petitioner's decision if it goes to a single member panel again, or it's our decision.
That's correct.
Okay,
Yeah, it's a good question, which is if it were to come back to the board and the board rejected it, can the protester then say, oh, well, forget this, I want you guys to just deal with it. We'll need to make sure
We do deal with it.
or that we handle it in procedures that say, this is not, once you start down this road, a single member, you're kind of committed, right?
Yeah.
It's,
So we can accept these for today's meeting.
right,
Go forward, talk to Judy or letter or whatever.
yes, agreed. So that's my proposal, and we're not gonna vote on adopting yet, okay? But my suggestion is that with the inclusion of that paragraph, we met the spirit of the law, which says we have to be aligned with the model hearing procedures. And we will let them.
But then do we add in later an addendum that
We will.
describes how we're going to do this?
I believe that we will have to amend our procedures to on how to handle
Yeah.
some more specificity, okay? And it may be in those steps, the steps that go, A to T, where we may have to add some subparts that say if it's a single member hearing, this is, come back and it's voted, blah, blah, blah. I just don't know all the specifics yet.
But at least we've got an option.
Oh, yes, we can certainly, if we choose to adopt these procedures, as you see as proposed on the tablets, there's nothing that precludes us to amending them, okay? And that was a comment when I chatted with Judy, which was, she said, you may wanna slow down and hold off on amending. Don't be in a big hurry to amend the procedures, okay? Because we may come up with a process and we may execute it and then say, whoops, that didn't work.
Just kidding.
Yeah, right. So I kind of agree that we, as best we can, deal with it. I think we may need to, through whatever mechanisms, just make if, for example, we have some documentation or something that we send to the protester saying, okay, you selected single member, this is what this means, this is what's gonna happen, blah, blah, blah. And that needs, I believe, be in a level of specificity so that we keep our butts out of jail, in terms of somebody trying to sue us or sue the district saying, you didn't follow your procedure.
Right, or you can tell us what the problem is.
Exactly.
Yeah.
Works.
But
Exactly.
yeah, your procedure that the model hearing has is very general, and so you wouldn't be going against that. You might, like you say, just figure it out this year, what works well, and then next year you could actually add it into the
Sure.
actual.
Oh, okay, that
Sure.
even sounds better.
You need a
So-
motion to accept this.
Well, let's hang on for a second.
Oh, okay, I'm sorry.
No, it's okay, because we do have a specific
There's nobody.
thing that we have to deal with from a public hearing perspective on the proposed,
I'm looking at the
procedures, but we'll get to that in a minute.
Chairman, I
Sir.
just want to affirm that I was thinking about the same thing, just I'm looking and there's no other participants waiting on the Zoom live. So from the public meeting standpoint, there's nobody here.
Okay, thank you. Can we take 1 second? I need something to wet my voice.
Now, do you want to come up here? You want to bring your chair? I suspect that we'll end up having two here. It looks small that way.
Yeah, I know, it's back.
Blank walls, boxes in the corner.
Some people I have talked to said that the comptroller's office is just punted because the level specificity on this is really, is not terribly helpful. That's why we get the big bucks, right?
Yeah.
Um, Okay, the last thing I'll suggest, and we have a meeting on the 19th.
Yes.
And right now, how many, you only have one hearing, I believe, scheduled for the 19th.
It's probably a couple, hopefully.
Okay,
Yes.
and when we had scheduled the 19th, we had indicated that it would be a morning and looks like we're just one. So what I will suggest, you guys can affirm or not, is that you have this stuff. I will send you copies of the things I had in paper for myself, just so you can refer to it. And between now and the 19th, give some thought to how we want to do this, what are the questions that come to mind, stuff that and we'll try and get that organized.
Want to do what? The meeting?
How we're going to address single member
Single,
counties.
okay.
Okay.
But you're also.
I probably won't until I get some more questions from you guys. That's true. That's true. But I've asked the schedulers how, to put off.
Oh, okay.
So they're going to collect, and right now I think is it 3 that I heard last week? So right now we have just three people from the protests that are coming. Sorry?
And they're not individuals.
They
Individuals.
Single.
They're not requesting.
They are. There was only three people,
requests.
three individuals that have requested single member
We
panels.
don't have to schedule them.
They're not scheduled,
Okay, gotcha.
because I asked them to kind of put them on hold. And there is I guess a reasonable amount of time that we could do that for.
Right, there is the wild card of the online scheduling option. We could possibly have someone schedule online, and then we would be faced with it at that point.
Yeah.
So if we are gonna come up with a letter, send it to you. All right.
Yes. And I clearly will put together my thoughts on this stuff. I may actually take a whack at coming up with a letter that at least is a strong hand that you guys can throw darts at when we get together on the 19th.
Yeah, you can send it to us before. If you can't.
I can do that singly. Okay. But there would be no discussion about, we can't, it is what it is.
Chairman, but you do have a public hearing and you do have consideration of possible action for the hearing procedures today.
Yes, we haven't gotten that yet.
Okay. Just want to make sure.
First.
So we're still on the same subject.
Yes, single member hearing, single member parents. So where we stand on that is I will send you a couple of notes that I have, things that I pulled from the tax code and stuff that's on your tablets that you don't have in hard copy, like my rendition of what this is about and stuff from the model hearing and from the training manuals and things like that. And those references will help you if you want to go crawl into the tax code, which is always good for. Yeah.
Nice remedies.
Yeah, right.
And then I'll ask that you try and organize your thoughts a little in terms of the questions. Because when I heard this Friday, Val mentioned it to me, and there was smoke coming out of my ears, and
I did talk to Judy, and it took me a while to kind of, I won't say calm down, but I just, you know, it really does present some challenges in terms of how we're gonna do this. I will take a whack at organizing a few items for a potential letter. We don't know yet. And at that point, you know, if when you get to that, and I may talk to you about that particular thing, which is to come back to anybody that requests a single member panel to be able to send them some additional information and say, this is what that means, what it implies, what it's going to involve. And so sending that alone, I think, is not a big challenge or a big issue. It's whether or not we can say, did you really mean that based on what you see now, and potentially have some mechanism through a waiver or whatever for them to hopefully, that may be the case. We'll find out. We okay? Okay, and we'll plan on reconvening this topic on the 19th when we get together.
And it's still gonna be in the morning, 8:30.
Yes, ma'am.
Just the morning.
Just the morning.
Just the morning.
Yeah, we'll plan on doing that. What time is we have to leave?
I was 10:30. I got time, yeah. It's right here in my book.
Thursday, the 19th.
Okay. All right. So moving on to item 7, public hearing on the procedures for adoption by the ARB. And I have something.
There's nobody else in there. You just wiggle it and look at the participants. Is there only one?
Yeah.
Yeah, then that's us.
First, I'd like to, when the guns come out.
Items.
Public hearing.
Yes. Yes. Public hearing.
Do that.
Okay, so pursuant to tax code section 5.103, subsection C, the board shall hold a public hearing, which is what we are in the process of doing right now, to consider the hearing procedures proposed for adoption by the board. I'm assuming right now that we don't have any other changes as a board that we're making to our hearing procedures. And that no later than May 15th of this year, that we will hold this hearing and make any amendments proposed. And since this is a public hearing and there are no people from the general public in attendance, either in person or via Zoom, that I will propose that, well, I'll entertain a motion that we adopt our hearing procedures as proposed.
I'll make a motion that we accept resolution adopting hearing procedures as presented by the chairman, which meet the Texas controllers on hearing procedures.
All in favor? Anybody opposed? Okay, so our hearing procedures as have been distributed and proposed are accepted. The next steps that take place is there are several things that will happen. One is I'll distribute or get a copy of these distributed to the district board of directors, the district's tax liaison, who is Josie Bonnet, and I will send these to I need to send these to the comptroller's office. And then lastly, these procedures need to be made available in 2 forms. One is posted here in the meeting room and online on the district's website.
entire thing.
Yes. Yeah, so what we're looking at doing is well, I've come up with a rendition in a 27 by 40, large poster format. So two poster size things
Oh,
will
great.
hang on the wall. It should work okay, it should be readable. And I think you guys have ordered frames are coming and we're in good shape there. Okay, I think that handles agenda item 7 and
Did we do 9?
Oh, okay.
we did 9, yeah. And in terms of item 8, I talked about what's going to happen or what needs to take place after with these adopted hearings. Okay, we've already dealt with options with item number 9. Do we have any, we don't have any letters to deal with?
Not this morning. These will probably show up on a later agenda.
Okay. And the intervening items taking us past 15 have been handled and voted on. Get my self-organized. Okay. At this point, I'd like to go to agenda item on your old business. Number 16. 47854. This is the set of letters in communication from Ms. Elmore. Excellent. Okay, so Val has gone through and nicely summarized or collected all these in one PDF file. I want to reiterate and emphasize that at this point, the only thing we are deciding on is whether to grant a hearing or not grant a hearing. We're not addressing the merits of the case at hand, or as it's described in the set of letters. Do we need to review those letters at all? Or y'all- Yeah.
We have them here, but.
Okay, to summarize, Ms. Elmore has had started with a set of letters on January 21st, talking about her appraisal, or in particular, her taxes having increased significantly on her residence, her homesteaded residence, which was replaced by the GLO. Okay. And she went through a lot of description about her particular personal situation. And a couple of points to, you need more detail on that?
No.
Okay. All right. So a couple of points that I'll make, and then you guys can chime in as required. The set of letters, in my mind, represents a fairly good faith communications attempt to, and prior to the deadlines. Okay, the deadline, the main deadline being January 31st.
for absolute drop dead date on any action, for any kind of hearing. Just, it wasn't made clear, I don't believe, because I went back and asked the question. Her taxes were paid in full prior to any of the deadlines, so that makes that aspect of a potential hearing for not being able to because of delinquent taxes. That's not an issue. During the first hearing where these letters were read, the district had not technically opposed granting the hearing. Question in large part became one of what kind of hearing and what would have been nice to have to kick off. My perception, and this is my perception, as you go through these letters, and you may or may not remember, is there's a general bit of confusion, and it's very typical with property owners on appraisals versus taxes. Also, if you go back and look at the actual protest form that was submitted, she indicated the years 2020 and 2021. However, with the lawyers indicate that really the only thing we could potentially hear is a protest as it relates to 2021. If we did grant a hearing, then that would, because of the timeframes involved, and these letters would need to be under 25D, which has its set of process of hearing the protest and then applying the calculation. I will ask Mike, is there any other information as it pertains to this letter, not pro con whatever, from the GLO that might influence or move or not move any this set of letters?
Well, what I'll say is there's information that's going to be presented at the hearing in reference to the GLO.
Okay.
But as it pertains to the granting of a late hearing as it refers to 25D, the district has no objection to the granting of a hearing. So I'll just say that.
Okay. Great. I was more concerned about the lights getting dim in the back office while the district is dealing with GLO adjustments, on a bunch of things. Okay. I did talk to the attorney over the weekend, and I dealt with the attorney. That was actually one of the main reasons why I got hooked up with Judy about this particular case. And I posed two questions as part of my discussions with her. One is the question of whether to grant or not grant a hearing based on the series of communications that have taken place. And then the second thing, which was a little more interesting from my standpoint, was how far can we go in a response from the ARB to either guide or inform Ms. Elmore about what she can and cannot do and should and shouldn't do, and try and, to some extent, make it very clear that what we're talking about here is appraisals, not taxes, in 2021 and that time. So that's all I'm going to say at the moment. Do you guys have anything else you want to add or offer a question?
Just to refresh my memory, wasn't there an issue that our taxes on the GLO were higher than previous taxes?
Yeah, the house.
It's important that you stick to the facts. That
You're
granting,
correct.
Granting, let's just talk about the letter.
Thank you.
The district is not opposed to granting the hearing. You should make a ruling at this point.
Anybody have a motion to do that or not?
I move that we have agreed to hear her protest. I'm sorry?
Yeah, you need to, the motion should include the property ID
Okay, and where is that?
and it's 478.
Yeah, property identification is 47854, that we hear her,
For being
protest.
Janice Elmore.
Janice Elmore. You got that?
I'll second.
Okay, all in favor?
Aye.
Anybody opposed? Okay, that motion carries to grant a hearing. Now, along these lines, little procedure, when we hear these letters, the man behind the curtain, or the lady behind the curtain, in this case, Val or Beth will craft responses that I then sign to send back as a result of either granting or not granting the hearing on these letters. In this case, since there was a little more specificity that I wanted to be able to inject in this, I did put together a response letter and pacify the lawyer to make sure that I didn't go too far, or did I go far enough and address this? So I'll read this, which is my proposed response that I provide to the district to send for as a response. Because we did, as a result of our last meeting, we did get a response sent to her, which just basically said that we reviewed the letters, we tabled any action based on the letters, and we'll consult with our attorneys before making a decision. So that's the last communication she received. Okay, so my proposed response is, dear Ms. Elmore, on May 9th, 2022, the Appraisal Review Board, ARB, reviewed your letters received by the Aransas County Appraisal District between January 21, 2022, January 21, 2022, and February 17, 2022. After considering your request, the Appraisal Review Board has decided to grant your request for a hearing related to your appraisal for 2021. Due to the timeframes and deadlines involved, this hearing can only address the appraisal for the tax year 2021 under Tax Code Section 2525D. Due to the timeframes and deadlines involved, any consideration for relief to your 2020 appraisal is not granted. So, she, in the protest form, had requested 2021, 2020. We're only going to deal with 2021. Please note that the ARB only addresses matters related to property appraisals. Thank you for contacting us on regarding this matter. Sincerely.
Did we already explain to her what it was? The previous letter?
I believe we did, and we provided in fact, it was a fairly lengthy, detailed response in that letter from the district talking about that, in addition to supplying it. Okay, so that's the proposed letter that I'm going to provide to the district to send us our response.
Okay.
Okay?
Good.
And I don't think that requires any motion. Okay, excellent. Okay, and we're probably pretty much done.
Okay.
But that's okay. If you need to leave, you
No.
can head out.
Just for this one, isn't it?
Yeah.
Look forward to next meeting. Yep, the 19th.
19th, yes.
I will be here and I will answer your texts. I know who you are. Bye-bye.
Okay, so we addressed item 16 on Ms. Elmore. And for our next ARB meeting, I think we have addressed that meeting from the standpoint that there's one, maybe two, or just a handful, small number of hearings, and we'll follow that with the discussion on single member payments. And in the meantime, I will send you guys any information that was on the tablets for you relative to the discussion that we had on single member payments. And as I develop any straw man set of documentation on what potentially we would send to the protester, I'll send that to you. I'll also pass that by the attorney to make sure that's okay.
And
Yes, ma'am.
Scott, on the 19th, if not before, the chief appraiser will give you the appraisal roll, but he said it may be before that.
Appraisal records for capture to ARB submission, it basically indicates, like, here's a representation of the totals that we have. Here's the total number of properties. Here's the ones that we currently have under ARB review, which have already requested protest. It's just gonna have the certified totals associated with that. I was informed that exclusive of that, so we had some documentation. We had some documentation associated with the last year, or not documentation, but in that ARB submission, we did talk about the minerals not being a portion of that, but then we would do a mineral import, and then we would tell you what that was. We would actually present that to you in a certified totals for the mineral import, but the minerals won't come in until late May, is what I was informed last week. So we'll give you everything that we have at the, to date in that 19th meeting.
Is there anything that needs to be addressed for first order?
You had a first quarter meeting.
I'm just thinking that we've met all the requirements for providing information for first order.
Yes, we had that April 11th meeting, and we provided we do the reports in the meantime anyway, but it has to do with those supplements.
Yeah, right.
And so between July 1st and July 10th, we'll need to have another little segment, and we'll present that
Okay.
25 report. And on the 19th too, we'll probably have the letters that we weren't quite ready with today.
Okay, I believe that covers all the items on our agenda. Anybody else have anything else that they need to bring up?
Make a motion that we adjourn.
My second.
Anybody opposed? Okay, and we stand adjourned.